Members, let's resume the meeting. If the administration is ready as well, let's resume the clause-by-clause scrutiny. We're on part 5. I'll give the floor to the Security Bureau. Part 5 and Part 6 relates to investigation. These are making inquiries. These are similar provisions, so I will read Parts 5 and 6 together. Part 5, responding to computer system security threats and incidents, and also relevant offences under Part 6. There are 2 categories. That's early intervention. In Division 1, the powers for the Commissioner to make inquiries before identifying threats and incidents, and the powers for early intervention. 29 sets out the conditions for early identification. If there is reasonable suspicion that an event has an actual adverse effect, is likely to have an adverse effect, then the Commissioner may investigate into the cause of the event or whether the incident or threat has occurred, and that is called direct inquiries. Clause 30 relates to the powers of authorized officers of Commission in making inquiries. In short, that means the powers to demand production of documents or information that are under the control of the operator or otherwise accessible in or from Hong Kong by the operator. 31 and 43 in Part 6 are related to the relevant offences and the powers for making investigation. Clause 31, if there are reasonable grounds to suspect that the operator is reluctant to cooperate, then the magistrate may apply for a warrant authorizing the officer to enter the premises and search, inspect, make copies, and seize and remove any documents where there are reasonable grounds. 39 also have a similar public interest provision. That is whether that is the harm or disruption that could be caused to the investigated threat or incident to the core function of the infrastructure, and also the benefits likely to accrue from doing the acts authorized by the warrant and the potential impact on the core function of the infrastructure, etc. The legal advisor wrote to us and asked about the information to be furnished to the magistrate in applying for the warrant. We have already given a reply. And then Division 2, Computer System Security Investigation. It sets out the power of the Commissioner to make investigation. There are 4 definitions. That is, despite being called investigation, it also includes the power to order remedial actions, etc. The CI operator is called the CI operator being investigated. Clause 35 refers to preliminary investigations, and then Clause 36, on meeting certain conditions, the Commissioner may further demand the CI operator take certain measures to assist in investigation. Clauses 37 and 38, the Commissioner may apply for a magistrate's warrant for entering the premises and demanding the CIO to assist in the investigation. And then 34, if there is reasonable ground to suspect that the threat or incident has occurred in relation to the CCS, then the Commissioner may demand that remedial action be taken. Now, the purpose of allowing the Commissioner to do the acts from A to E is, well, to better clarify our intention, we'll consider moving amendments. Preliminary investigation powers. Now, in Clause 35, as mentioned in Clause 30, basically they relate to the powers to demand explanation or furnish particulars, and then additional powers in Clause 36. If there are reasonable grounds to believe that the investigated CR operator is unwilling or unable to take all reasonable steps to assist in the investigation or respond to the threat an incident, then there are a number of things that the Commissioner could do, for example, to demand remedial measures, etc. Clause 37. The powers are similar to those in clauses 35, 36, only that a magistrate's warrant would be required for the power to be exercised. As I mentioned, we already replied to the legal advisor's question. Clause 38 relates to the magistrate's warrant for entering premises for the purpose of investigation. Clause 39, conditions for issuing warrants. Clause 40, power of entry in emergencies. Even without the presence of a warrant, these acts under 38 could be performed. These are specified acts. Clause 41, supplementary provisions in Division 3, use of incriminating evidence in proceedings in investigation. For the offense under Section 42 of the bill or offense under Part 5 of the Crimes Ordinance are exempted. As for penalty, $500,000 fine. Next, Part 6, investigation of offenses. These are similar provisions relating to offenses under this part. Again, the regulating authorities may demand the production of documents, information, and they are similar to the powers set out in the Clause 41. The maximum penalty is $500,000. Clause 46. Magistrates' warrants for entering premises or accessing electronic devices for investigation. Now you have very roughly walk us through these clauses. So let's see if there are questions from the floor. On the whole, I think the overview is helpful in the sense that we can have a better picture of the powers given to the Commissioner during the early intervention stage and what additional powers are given. For example, let's see if there are questions relating to this overview. Mr. Lai Tong Kwok, just a point of observation, that is the conditions for applying for magistrate's warrants. I think that these are really rigorous. These are watertight. In other words, it's not easy for the Commissioner to have access or to enter the premises. The magistrate must be satisfied with all the items set out here. Only when all the conditions are met will the warrant be issued. I think this should be emphasized. Thank you. Right, no more questions on the overview. How about another explanation to us about, say, Clause 29? The Commissioner reasonably suspects that an event has occurred. Now, to reassure the operators, you need to explain to us that when it comes to ensuring the computer system security, we do things step by step. We don't need to wait for a threat or an incident to happen. When it comes to early intervention, sometimes it may involve the occurrence of an event which could lead to a real threat or an incident. So can you give us some examples? Let's see if you have come across any case when there is a sudden surge of traffic or ransomware incidents and the early signs.
Thank you, Chair. Right now, our design is that for an operator and there is a specific incident, we would be monitoring the situation. But when there is an event, we will only be we'll only practice early intervention when there is cause for concern. I'll let Mr. Francis Chan supplement my answers. Let me give an example. We have an international hacker group. They may have just used ransomware to attack a power plant overseas, and they have made advance notice that they would attack a power plant in Hong Kong. We would be made aware of this, and then we'll first communicate with the power plant operator to see if they know about this or if they are threatened by ransomware. This is an example of how we will practice early intervention to make sure we get the right information and communicate that we should intervene early. So I believe you will be following not only local situation but also what is happening in the rest of the world with this answer. And you say here in clause 29 that there should be at least likely to have an adverse effect for you to intervene. And also in clause 29, you are making inquiries for the purpose of identifying what caused the event and whether a computer system security threat or an incident has occurred in respect of the system. Clause 30, Ms. Choi talked about some powers. Can you elaborate on what powers there are? Alright, say in subclause 1, we will be referring to some factors on whether we should obtain relevant documents from the operator for investigation or inquiry. So the first step would be obtaining relevant documents for us to make an assessment to see whether there is indeed an adverse effect or whether there is already an incident. But of course, there is always proportionality. We would make sure that it has to be justified. Alright? In C2977, the documents must be at least relevant. And when addressing your inquiries, the documents must be possessed or under the control of the operator or otherwise accessible in or from Hong Kong by the operator. Right. We would perhaps require the operator to give explanations. If necessary, we'll meet with them before we can make a proper assessment. But of course, there is a deadline for that because we must make sure action is taken in time. And if necessary, we may seize evidence or we may reproduce the relevant evidence if necessary and take extracts from the document. Alright, so in C in particular, it is said that a representative will be sent to attend before the officer at a time and place specified in the notice and basically answer questions for you to find out the cause of the relevant events or incidents. Correct. Clause 31. There must be a written notice first, as said in clause 30, and then in clause 31. It says that when a magistrate is satisfied that there are reasonable grounds to suspect that there is on any premises any document relevant to the inquiries, one may enter the premises. Can you talk about clauses and clauses 33 as well? Give some sort of elaboration. Alright? Again, For Clause 32 in particular, there must be reasonable grounds to believe that the CI operator is unwilling or unable to take all reasonable steps to respond to the inquiries. And there are reasonable grounds to believe it is in the public interest to issue the warrant. And there are some factors to be taken into account as set out here. The potential harm, the potential disruption, the benefit likely to accrue from doing such acts to be authorized by the warrant, as well as the potential impact of doing the acts. We will make sure it is in the public interest to issue the warrants. Okay? I specifically note that in 32B3, it says whether or not the purpose mentioned in Section 29 could be effectively achieved if the warrant is not issued. So even if the warrant is not issued, if the purpose can be effectively achieved, one would not have the warrant issued because they can still enter the premises. Indeed, it is only when the CI operator concerned is unwilling or unable to take all reasonable steps to respond to the inquiries. I believe the legal advisor also has some questions about Clause 31. Thank you. We wrote to the administration. Please refer to paragraph 22 of our letter. There are 3 provisions involved. So, Clause 31 and Clauses 38 and 46. Basically, when the agents have to enter by force, excuse me, I was referring to paragraph 15 of our letter, and I'm talking about paragraph 22 of the administration's response. Sorry, I talked about the wrong paragraph numbers. So in paragraph 22 of the administration's response, if need be, clear guidelines will be provided to the authorized officers in enforcement. Would the administration consider elaborating on this? Under what circumstances would you provide clear guidelines, and what kind of guidelines are you providing to the enforcement personnel? The content specifically. So if one has to use force to enter premises, and if one will chance upon sensitive data or trade secrets, are there any guidelines for the officers to know how to deal with such information? Thank you. Administration. Thank you. The different enforcement units of the Security Bureau would have different enforcement guidelines to facilitate frontline officers to follow the laws. This is no exception. I'll perhaps ask Raymond supplement my answers to provide more information to members for members' reference. Thank you. In daily operations, we often have guidelines for enforcement operations, and we would often chance upon personal data or different documents, really. We have clear guidelines on how to handle such information. With these data, we do not require personal data or trade secrets to be given to us, and therefore we would try to protect such data. And it is also said in law, with data acquired during such operations, such data should not be leaked, and they will only be used for investigation purposes. Thank you. Thank you. So Division 1 is about early intervention. If there are no other questions from members, let's move on to Division 2. We did talk about Clause 34, how there should be investigations to be carried out in relation to computer system security threats or computer system security incidents. In Clause 33, we have some interpretations, essentially defining the scope. In Clause 34, you have some aims for investigations. So you said that it can be any or all of the following purposes, right? Alright, let me be clear here. If we suspect there is a threat or an incident, we will take this second step here, and the policy intent is to have any and all following purposes, and we will review with the DOJ colleagues whether there is any other better wording. But as said earlier, we will make sure there is clear wording that is any of the following purposes would suffice. Alright, for A to E, it's any of them, right? Alright, if it is any of them. Why is it that when for any of them that you would be directing investigations to be carried out? Definitely. For A, identifying what caused the threat or incident. In fact, there are different circumstances in each case, but as always, identifying what caused the threat or incident is definitely important. B, assessing the impact or potential impact, because we need to know whether other industries may be affected. C is also important. Should there be any harm, it is important to remedy the harm and how we can reconstruct the system as soon as possible, or how we can stop the attack at least. For D, preventing any or any further harm. Once, for example, there is an incident, will there be further harm? For example, a banking system has been attacked or hacked. It may affect, say, withdrawal services. How can we prevent further harm? I think there are many possibilities. The one I just said is just an example. E, preventing any or any further computer system security incidents from arising from the threat or incident. We need to think about whether other firms in the industry or even other industries may be affected. So this is also very important. We will make sure that the power is not unlimited, but then we also want to provide some flexibility. That's why we want to have A to E, any of the following purposes met, and one, the commissioner may direct an investigation to be carried out. Alright, so there is identification of the hazard and assessing the impact and remedying the harm. I think, Chair, if I may interrupt, in reality, it would be the case that we may be looking at different things at the same time. It may not be a step-by-step process. Depending on the circumstances, if we have a reasonable suspicion, say there is a threat, we may refer to the different things. Alright, so I think you are talking about for one or more of the following purposes, right? Yes, but I'll leave the drafting decision to be made by the DOJ colleagues. Members have no questions about the later clauses, but then I also want to ask you to elaborate on, say, clauses 35 and 36 on the powers of authorized officers and additional powers. Clause 35 is something basic, because for early intervention there is a need to have powers in order to conduct investigations, and we can have them have the operators send a representative to answer some questions, and we can obtain documents. Clause 36 is for when there are special cases, additional powers will be required. Then, therefore, we would need additional powers because we have already reasonable grounds to believe that the CI operator is unwilling or unable to take all reasonable steps to assist in the investigation or to address the investigated threat or incident. For example, if they are unwilling to give us the documents, we will need additional, or we will exercise the additional power. And also, their commissioner must have reasonable grounds to believe that to be the case and that it is in the public interest. So this is also a controlled power. So what kind of powers would it entail? We would ask, for example, to have the CI operators to stop using the investigated system to preserve the state of the system, to monitor the system. I will perhaps let my colleague supplement my answers to provide a professional perspective, but this is the basics. Also, we may ask them to perform a scan of the system to detect any vulnerabilities and assess the impact of the threat or incident, and more importantly, to carry out remedial measures. I'll perhaps let Mr. Francis Chen give some actual examples of these. Thank you. Thank you. In my previous experience in the CSTCB of the police, it is often a coordination or coordinated approach. The team will work together, and say for the CSTCB, they will help right after the incidents. They will provide assistance to the organizations. They may visit the premises. If there is an attack, there is a crime, for example, the police would have to collect evidence. But when the operator is trying to restore the system as soon as possible, it may delete some data. Therefore, we are trying to foster partnership with stakeholders to strike a balance so that while they strive to restore the system, we can still preserve information about the threats or incidents for our investigation, to inquire evidence about the crime, or for future reference for us to prevent similar occurrences. Ms. Elizabeth Court, I agree with what was said, but let me say this again. As I said before, it is very important to train the staff. There may be information that would only be preserved at that point in time. Once the machine has been rebooted, it is gone. If training is not provided, if you have no clear information in the codes of practice, or if you do not specifically adhere to the ISO standards, it may be hard for people to follow. So I urge the administration to make sure proper training is provided to the staff members concerned, because we don't want people to act irrationally or with no proper guidance after incidents. Of course, we will make sure there is a plan, and we will make clear our requirements in the codes of practice to make sure we adhere to international standards. So in C2987, you talked about the different acts that I guess you have derived them with your experience, what to do, and basically there's also a catch-all provision in F that one must provide all other assistance in connection with the investigation that the operator is reasonably able to give. Right.
37呢，我
I would like to compare it with Clause 37 in the moment. Clause 37 applies to organizations other than CI operators and also the requirements imposed on them. Now, for these actions, a magistrate's warrant is required. For Clause 36, however, it just requires a decision to be made by the Commissioner. Yes, the power must be proportional. And concerning cases where the Commissioner can make a decision, these are cases or powers in relation to CI operators. Now, for organizations other than investigated operators, the bar should be higher. A magistrate's warrant should be required. However, the powers to be exercised is the same. That is, requiring documents or information from the organization. So, a warrant application would be made by the Commissioner. Any follow-up questions? Now, would delay be an issue if a magistrate's warrant is required, since these cases are usually urgent? That is an important point. We will come to that later in Clause 37. If a warrant is denied by the magistrate, then Clause 40, the emergency response, will be invoked. That is an emergency power to gain entry into the premises. But of course, if a warrant can be secured, that would be great. If not, if the situation is not practicable for us to obtain a warrant, then Clause 40 will be invoked. But since you mentioned C229A, that is the power of entry in emergencies. Now, brackets 2B, the bill says that for emergencies, these situations covered operators, B1 and B2, the organization mentioned in section 37, brackets 2. So this is what Ms. Kwok's question is about. Emergency may relate to organization other than operators. So for Clause 36, brackets 37, brackets 2, the organizations, what are these organizations? Now the paragraph says that the organization appear to have control over the investigated system other than the investigated CI operator. So what kind of operators are these? Are they the parent company of the operator who are not in control of the system, or third-party operators? Thank you, Chair. Now, the scope is not unlimited. The organization has a controlling authority over the investigated CI operator. So like my colleague suggested, third-party or third-party contractors engaged by the operators are an example. It depends on whether the organization has a controlling power of the system. So I think the police should be more clear about this. Some operators may rely on the system of the parent company in running their infrastructure. So the powers can only be exercised on organizations which have controlling power on the system. Allow me to elaborate. In case of emergency, and in terms of offering services, an organization would offer these services by way of subsidiaries as well as third-party contractors. So these are all the stakeholders in the building of the system. So they all hold valuable information for our investigation purpose. So this power can be exercised on these organizations as well. So are the powers in Clause 37 the same as those before? Yes, the only difference is that to exercise these powers, a magistrate's warrant is required. Moving on to Clause 38, entering premises. So can the administration explain this power? Again, to apply for the warrant, the thresholds of public interest as well as failure or unwillingness on the operator's part to comply with the direction must be met, and also the information must be pertinent to the investigation, and also the investigated system must be located within the premises. Since entry into the premises is required, a magistrate's warrant is required. Now for details, the power includes gaining entry at all times, seizing the articles or perform remedial actions. This is important because we would like to restore the system. In terms of remedial measures, these are similar with other clauses. Mr. Benson, look. Thank you, Chair. Clause 38, brackets 1A1. The expression likely to be on any premises anything that is relevant to a computer system security investigation is mentioned. Now, the administration has said that the bill will not affect trade secrets or personal or data in relation to privacy. Now, how can the investigators distinguish between information relevant to investigation and information related to personal privacy or trade secrets? Thank you, Mr. Benson-Look, for your questions. I reiterate, the objective of the investigation is never for the purpose of obtaining trade secrets or personal data. It is for investigating the emergency event. So during the resumption of second reading debate, the Secretary will reiterate the legislative intent. So how we can ensure that our frontline staff our frontline law enforcer are meeting the requirements in the law. Now, we will issue an internal guideline to make sure that our frontline staff are in compliance with the law. Mr. Ambrose Lam. Thank you, Chair. There are lots of provisions in terms of protecting the critical computer system and also the investigative powers. The Commissioner has the power to investigate and restore the computer system. Now, when there is an incident arising from geopolitical tension and other human factors, if you refer to a clauses 37 and so on, the powers include preserve the state of the system, not to use the system and monitor the system. These are all powers to advise the operators to do something. But does the authority have the authority? Does the government have the authority to take over the system when the operator fails to obey? Thank you. The first responsibility and the first responsibility to maintain the system is with the operator. Failing that, we would intervene. I'll say backup. The Commissioner's office, together with other departments, including the police force, would take remedial measures. But what about taking over? So you are just restoring the system and give it back to the operators, but you can't just trust the operators. We're talking about major infrastructure critical to the operation of society. So what about the power to take over the infrastructure? So is there such a provision in the bill to allow the authority to take over the infrastructure? Clause 38, 2C, 2B and C. But there is another hurdle, that is the magistrate's warrant. Clause 38, 2B and C, page 2993 in the English version. C. Carry out any remedial measures and access and inspect the system. Part B, power of inspection, make copies of and take extracts from the premises. Now please study my suggestion. Mr. Lee, maybe we can make reference to similar provisions in other ordinances concerning the investigative power of the authority. So this is about taking over the system during the investigative stage. So according to experience and under other ordinances, has the power of taking over been invoked? Now we have made reference to the law in Australia. Now may I invite my colleague to elaborate? Thank you, Ms. Lee, and thank you, member. Now the issue is taking over the operation of the system. Now, clause 38B and C the powers refer to taking over of the system to conduct remedial measures rather than the operation of the operator. I mean, this is so important that it relates to the operation of society. To take human factors out of the equation, maybe the police force has to take over the system. Is there a power where the police force or the administrations can take over the system whenever the operators are not to be trusted? Now, taking over of the authority to operate the infrastructure, that's not what the law seeks to empower us to do. That is to be dealt with under the Safeguarding National Security Ordinance. Now, as long as there is a power, I don't mind. The bill focuses on helping the operator to fulfill the security requirements. Now, for behaviors affecting national security in relation to critical infrastructure, it is a very serious criminal offense under the Safeguarding National Security Ordinance. So we would conduct investigation according to the power under that ordinance. But I think they are related. Besides national security, it also relates to the operation of our society. If a party deliberately suspends operation of our, say, traffic system, you need to take over the operation at once. But of course, national security is a higher level. I believe that is needed because we are talking about the operation of our entire society. We will study your suggestion and give you a reply later. Mr. Benson, look. Thank you, Chair. Clause 38(2)(c), access and inspect, the power to access and inspect. Now, of course, the data can be stored or the system can be run from anywhere outside Hong Kong, given the technology. So the system may be located outside Hong Kong. It gives rise to two issues. If a warrant is issued by magistrates, can the authority gain access to a system located overseas? Now, in case of an incident, if the hardware of the computer system is located overseas, there is a possibility where foreigners are interfering with the system. So it seems that we can do nothing about them. Now, access means gaining access to a computer system, not necessarily in Hong Kong. Now, interference, it also relates to the severity of the offense. Under the Safeguarding National Security Ordinance, there is an offense concerning interference with a computer system to endanger national security. For this bill, we are just talking about helping the operator to put the operating system back up. In other words, even if the hardware of the computer system is located outside Hong Kong, the power of gaining access as granted by the magistrate's warrant is still valid, correct, provided that the system can be accessed. Mr. Patrick Lee, the clause is about the power to investigate. A magistrate's warrant is required. We understand that. Now, 38 brackets 2B and C, gaining access and to inspect the computer system. We have heard the explanation from Mr. Chan. The key is to gain access and then inspect the computer system so as to take remedial measure to deal with the threat. That's the focus. Now, the definition for accessible system in bracket C, it includes the investigated system or another computer system. So the power is extensive, but we all know that the bill carries no extrajudicial effect. So in terms of providing assistance to the investigated party, the investigated operator, if the company in control of the system is located overseas, then we have to understand that you will have to exercise your power by gaining access to that computer system. So I think that is very clear. In reality, this is a balance between the extrajudicial effects of the bill and the power to gain access of a computer system overseas. Now, the bill covers system located in Hong Kong or system which can be accessed from Hong Kong. Now, you may need to get the password to gain access to the computer system. You need to gain the access right. So the operator cannot say that the password is a trade secret and we can't give you the password. They can't do that. So you haven't ruled out the possibility where passwords or some personal data have to be given to the authority in order for the authority to gain access and inspect the computer system. Am I right? A balance has been struck. The bill carries no extrajudicial effects.
Thank you, Chair. It's true that this bill does not have any extraterritorial effects. Now, we're talking about access to the system for information to be retrieved, and this is really common because very often data are stored on the cloud, and it's impossible for us to have physical control over it. The important point is to have access to the system. We also have different hurdles to make sure that the conditions are met before the power is exercised. Computer security incidents and threats, and that's the key. We don't require personal data or passwords to be provided. We don't go after personal data or trade secrets, but it is possible that we may come across personal data or trade secrets in the process of investigation, and that's where Clause 57 kicks in. Preservation of secrecy. We must make sure that the data are kept secret, and that's the responsibility of the Commissioner's office. It's a criminal offense to breach this provision. Right, we now are clear that whilst not intending to go after personal data or trade secrets, we cannot rule them out either. You've explained the reason. All right, please move on. Clause 39, conditions for issuing warrants. You've explained the conditions. And then powers of entry in emergencies. Can you explain the difference between Clause 39 and 40? That is, under Clause 40, certain acts are not allowed. Now, if a warrant cannot be issued despite having taken all reasonable and practical steps, for example, it's the CI operator is reluctant or unwilling or unable to cooperate, etc. These are the same conditions. Mr. Lai Tong Kwok. Now, my question is this. Under what circumstances do you think you will not be able to apply for a warrant from the magistrate? Because as the PS mentioned, only when it's practically impossible for a warrant to be applied for from a magistrate will you go by this clause. So can you tell us what are the scenarios you have in mind? Because Hong Kong is a small place, you can visit a magistrate's place in the small hours for the warrant. I'll give the floor to Raymond. Thank you. In terms of enforcement, we do run into these situations. Hong Kong is a small place, but in spite of this, we do have such situations. We do visit magistrates' places in the middle of the night, depending on the urgency of the case, and because of other official duties or other personal reasons. They may not be able to issue a warrant in time. Even within a time frame of 10 or 20 hours, that may be long enough for us because when it comes to investigation, we'd like to take it forward as quickly as possible. C in English, it says to obtain. In Chinese, it says 取得, which means obtain. Now, if you envisage that the magistrate so visited will be rejecting your requests for a warrant, then how are you going to exercise his power? Now, it's not the case that the magistrate cannot be located, but rather that the magistrate refuses to issue a warrant. I'm sorry, I didn't catch it. Now, we're not going to invoke the next provision simply because we expect the issue not to be, the warrant not to be issued. It is the case in which the magistrate cannot be located. Like Raymond said, in the small hours, the police may not be able to locate the magistrate, and there is no alternative but to go by the next provision. All right, so time-wise, due to unforeseen circumstances out of your control, it is impossible to approach a magistrate, and only under such circumstance would you invoke this power. Right, now that is clarified, we understand the legislative intent of this provision. And it's not the case that if the magistrate doesn't issue the warrant, you will go by the emergency route. Now for 38.2, that's page 2993, it lists out certain powers except 2A. 2A refers to a period of 7 days within which, after the warrant has been issued, the commissioner is authorized to enter the premises. So is it the legislative intent that when it comes to an emergency situation, you will not invoke the this clause 38.2a and the relevant period of 7 days? That's true. In case of emergency, the circumstances will be quite different. Because of the urgency, we don't impose any time frame. By the meaning of emergency, we need to enter the premises on an urgent basis. Right, so the power under 38.2a is excluded here. Right, back to 40, subclause 3. The authorized officer entering the premises must produce the authorization for inspection. Can you also explain to us, with reference to clauses 50 and 51 in relation to authorized officers, because we've covered the term quite frequently, the term authorized officers. So that means even in case of emergency, the authorized officer must not enter the premises willy-nilly. The officer must produce or come with the authorization from the commissioner. Authorization may be given in relation to some specific acts. So the commissioner will authorize the officer to do certain acts. We put in the safeguards to make sure that the officer acts within the authority of the commissioner. All right, if there are no other questions, we now move on to Division 3. Clauses 41, 42. These provisions can be commonly found in the laws of Hong Kong. I will invite Ivan to explain the legal points. These are common legal proceedings. Mr. Lau. Clause 41. The safeguard can be found in other ordinances. That is, to safeguard the right of the person who is required to answer questions. There is this legal principle of privilege against self-incrimination. There are case laws in the Court of Final Appeal that changes could be made to this principle through statutes on the grounds of public interest in the case of investigations. Now, for the person under inquiry, the answers so given may be incriminating in the subsequent legal proceedings. So safeguards are provided in the Basic Law as well as the Bill of Rights Ordinance to ensure the right to a fair trial at the prosecution stage. So we spell out here that if the person under investigation exercises the privilege against self-incrimination at that stage, then in the future, when he's prosecuted, this piece of evidence cannot be used against him unless the purpose is to prove that it's lying. And in fact, this is a common provision in different ordinances in Hong Kong, and the provisions are in line with the case authorities. All right. Clause 42 provides a defense, and that is for offenses relating to Divisions 1 and 2 of Part 5, whether the organization complies with a specified requirement. And then if we turn to 3009, we see the definition of specified requirement. In fact, it's 3003. The maximum fine is one of $500,000. What is the consideration? Is it on the low side for those not being cooperative with the investigators? We consider the proportionality and appropriateness of the level of penalty. We find the penalty level of $500,000 to be appropriate. Apart from the powers given to the investigators, in the framework of CAT 1 to 3 obligations, the Commission's office may issue practical guidance and written directions. Failing to observe the directions will attract a penalty of $5 million. So depending on the circumstances, there are different ways to ensure compliance. And in a more extreme case, the financial penalty will be higher. And at this point, we believe the $500,000 fine would be sufficient. Right. My take is that when it comes to CAT 1 and CAT 2 obligations, the focus is on prevention. For CAT 2 obligations, I'd say that the penalty levels are relatively higher comparing to non-compliance with the directions during the investigation stage. Because it says here on summary conviction, a maximum fine of $300,000 or conviction on indictment, a fine of $500,000. I'd like you to review this because investigation is also essential. Because this is when something has happened, and if the penalty level doesn't correspond to the seriousness of the offense, I don't think it's right. Please go back and give it a thought. Mr. Lai Tong Kwok. Point of clarification. Clause 42(1). I see this phrase, reasonable excuse, expressly provided. And then 42(2), you refer to a special circumstance, and that's self-incrimination. That is, the evidence given or the testimony is used against the organization, and that is not a reasonable excuse. On top of those, there must be various reasons or excuses that the organization in question will put forward as a reasonable excuse. So it's up to the court to decide whether it constitutes a reasonable excuse. In preparing the code of practice, will you include some examples to illustrate what circumstances or what reasons do not constitute a reasonable excuse? Now, I know that the code of practice does not form part of the law, but the court may consider the code of practice when considering whether the evidence is admissible. Now, if you provide examples in the code of practice in which an organization clearly is not compliant with the specified requirement, then it will help the court decide whether it's a reasonable excuse. Will you do that? Thank you for the question. In the code of practice, we will expressly provide conditions for meeting the Category 1 to Category 3 obligations. We will not interpret what a reasonable excuse means, but we will provide examples about Category 1 to Category 3 obligations. For example, as mentioned, there may be an accessible system operated by the Hong Kong operator, and this is managed by a third-party service provider coming from another jurisdiction. Now, say in that country, there may be requirements forbidding the third-party service provider providing information to the Hong Kong operator. So in the code of practice, we will provide the circumstances, for example, in engaging the service provider, the CI operator need to consider whether it meets the requirements and laws of Hong Kong. And if in the third party's country there is a rule, there is this rule not to allow the information to be provided, then in the first place it's not in compliance with the law. But thank you for the explanation. Since the CI operator will be responsible for complying with the rules around the world, and like you said, if the CI operator deliberately chooses a third-party service provider in a way that information cannot leave that country, then this is also the responsibility of the CI operator in selecting the right service provider. Ms. Elizabeth Quat, I also raised this point before. This could be a possible issue. This could be an issue. Like the PS said, of course, the CI operator should be careful in selecting the third-party service provider. In signing an agreement, at the outset, the service provider is cooperative, but then there may be a change of hands, and later on, the third-party service provider may be reluctant to cooperate. So the code of practice should spell out the steps that follow should the service provider becomes unwilling to cooperate. Now, the code of practice should also come with some criteria to help us comply with the requirements. For example, if it becomes known to us that we are not able to retrieve data from from the systems stored in certain countries, then there must be local backup. Otherwise, all of a sudden we may no longer have access to the system. You also need to draw up compliance framework that could meet both local and overseas standards to help CI operators in selecting the third-party service providers. They will go through this checklist. Next, I know that there are mirror sites. It can be part of the technical requirements so as to address the issue I mentioned, and that we won't be unplugged all of a sudden because of geopolitics. It is possible that such scenarios may arise. Just like Panama Canal, it's possible that the contract may be declared void overnight. So we need to come up with technical arrangements such as local data backup and mirror sites.
個員講得好。
I think these should be included in codes of practice. Permanent Secretary, I think it is as Ms. Elizabeth Court said, we need to make sure we conform to the 3 principles I mentioned. And we always need to have a bottom line in mind. Thank you. All right, please proceed. I think we have completed scrutiny of Clause 42 and by extension Part 6, investigation of offences. In Part 6, are there any provisions that are different from what you have for the investigation of incidents? Let's start from Clause 43. In general, the powers are similar. The wording is also largely similar. The main difference is that now with investigation of incidents, there may be some limitations to powers. With offenses, there will be a focus of the investigation of getting evidence for the offenses. But they are largely similar for the investigation of offenses and that for incidents or threats. So there are some that do not require a warrant, some would require warrants. That is in general how it works. As for the conditions for issuing warrants, they are exactly the same. All right? Any questions on this part? Part 6, clauses 43 and 44. On clause 44, I would like to get some clarification on subclause 3. It talks about some exceptions. Well, in fact, it is drafted in the same way as clause 41. I'll perhaps ask my colleague to provide more information on this. Yes, Mr. Ivan Lund. Thank you. Clause 44.3. The exempted offenses, essentially, and offenses under section 45 that would involve one not answering the relevant questions. And then if one is self-incriminating, then that would be a reasonable excuse. Well, it is not an excuse not to comply with the requirement. And there is also a false oath for the offense under Part 5 of the Crimes Ordinance. If you're talking about providing false information and one has to be charged, then of course we have to obtain the relevant information. So these are the 2 exceptions. One would have to answer questions, but then for the future criminal proceedings, they will be protected from incriminating themselves. I think it is just as Mr. Lai Tong Kwok said, there is reasonable excuse, the defense, and when selecting third-party service providers, we should spell out specifically the factors to be considered in the codes of practice. If there are no other questions from members, let's move on to Part 7 when you're ready. Thank you. Part 7 is about appeals, and on Clause 47 in particular, it is about appeal panel. And the appeal panel should include at least 2 IT professionals and 2 legal professionals, as well as 2 of those without the aforementioned background. Appeals against decisions, Clause 48. So it would be decisions to give directions, make designations, or impose requirements. In general, we wouldn't allow for appeals, but one can apply for a stay of execution. And then after that, one may lodge an appeal against a decision to the appeal board, but then after that there would be written reasons. That would not undermine the right of the courts to make decisions. Clause 49, decisions of appeal board. And then with Clause 50, we have to have authority of those who are legal professionals. And then after that, there should be a committee that is appointed. The committee should have at least 3 officers. And that there should also be other officers. And for Clause 51, we have some appointment of authorized officers by designated authority. We have a time and place and what the powers of the appeal boards are, including inquiring witnesses. And in general, the hearings will be non-public because we want to make sure the identities of critical infrastructures will not be disclosed. We also have some powers that will be given, and these will be parallel to a court process, and they are similar in a way. I want to ask about particular for Schedule 7. Is it the case that the appeal board would adopt a similar approach and with at least 15 members? These are the sending members, that is every time you draw members from that pool. Okay? For the appeal panel, it is not found in every jurisdiction. We just want to provide a channel for operators to see if there is a need to appeal the commissioner's decision, then there would be an additional layer of protection. Also, when we are proposing 15 members, we have referred to other legislation, including the legislation for property management personnel as well as the tourism industry, and that one should be a former judge, and there are some that should be IT professionals, legal professionals, and there should also be people who are neither IT professionals nor legal professionals. So that's how we are selecting the relevant members, the relevant criteria, but the process works similar to any committees, really. So you have talked about clauses 47 and 48. Any questions from members on these clauses? Clause 47 or 48. Or legal advisor, you have some questions. Yes, I have a question about clause 48. Under what circumstances may an organization lodge an appeal? And I have already written to the administration on this. Please refer to the letter, the legal advisor's letter, paragraph 19, and paragraphs 27 to 29 of the administration's response. Not all decisions may be appealed, and the administration gave an example for the commissioner's decision to exempt certain operational responsibilities of the CI operator. The decision is not one that can be appealed under Clause 48. The administration also gave a response in paragraph 28b. The administration stressed that whether to allow such exemption would be a discretion exercised by the commissioner, and it should be left to the commissioner to make a decision rather than the appeal panel. So say if an organization is aggrieved by the decision to not have an exemption, is it the only channel available to the organization would be to lodge a judicial review when such discretion is not exercised by the commissioner? I wonder if the administration has anything to add, whether the expression that not all decisions may be appealed. Permanent Secretary, I think the policy intent is clear. This appeal panel is not available in many jurisdictions, so this is an additional feature that we have. In addition, for the commissioner's decision, it is an additional responsibility or an additional power, and that would provide additional protection. We don't think exemptions are a must-have feature, say, for the CI operator. If one considers one should not be designated as a CI operator, they can lodge an appeal already. We do not have to wait until the specific features that they are against to lodge an appeal. So I think with the wording here, we have achieved our policy intent. Mr. Lai Tong Kwok, I would like to follow up on what the legal advisor said. Whether to allow the appeal panel to deal with appeals. If one is aggrieved, one may still lodge a judicial review. And honestly, I think some may misunderstand how the scope of the judicial review can be quite wide. It is not the case. It is actually quite limited. It can only be on executive decisions. And we are talking about the commissioner's decision to exercise discretion. The discretion should be limited. Only under unreasonable circumstances the decision can be revoked. And basically, you have an added structure here with the appeal panel. So one may say, or one may approve, revoke, or alter the decision made by the commissioner, and the appeal panel essentially would override the decision of the appeal panel, would override that of the commissioner. I think that is good enough instead of allowing every decision to be appealed. Now, with the membership of the panel, you would have some former judges or legal professionals, but often we have seen appeals taking a long time to process. Would you offer remuneration to the the members of the panel. Also, you would have administrative support for the panel. How much resources have you earmarked for the operation of such administrative support? Are you going to apply for additional funding, or do you have resources earmarked already? Thank you. Permanent Secretary, Mr. Lai's observations are quite correct regarding the former part. As for remuneration for members, we will follow up on this later once we actually implement the regime. We would, of course, need to have a secretariat supporting the operations. That will be a dedicated office. We will have Security Bureau colleagues support the operations. As for whether we can make use of existing resources, we will try our best. It is only under strenuous circumstances that we would ask for additional funding. I have a short follow-up question, Chair. So you would have an office that would be independent from the Commissioner's office. It would still be a part of the Security Bureau, but it has to be independent, right? I can confirm that it is independent. Just like any other secretariats for independent bodies. I think this is important because there should be finality of decisions, and we need to make sure there is neutrality. Dr. Chen Han-pan, I think having an appeal panel is important. One can lodge an appeal through the appeal panel, but we have seen before with, say, the housing appeal panel. For many cases, once a decision is given, one would lodge an appeal. If the appeal has a low entry threshold, one may just try to lodge an appeal anyway. Then that would be unnecessary work to be done, especially when the appeal has no merits. So would you make sure there is some cost involved so that there won't be people abusing the appeal mechanism? Because we have seen the appeal mechanism being abused by certain people. Perhaps we'll ask for fees to be paid, or when one loses the appeal, will there be any costs? Thank you. Permanent Secretary. For a particular organization, if one lodges an appeal for every aspect, whether to be designated, it can not really stop what the office is doing. As for costs, they will need to bear the costs if their appeals do not have any merits. So I believe people will only lodge appeals when they feel that they have merits. And they would think about whether it is justifiable. And I do thank Dr. Chen Han-pan for your suggestion about preventing abuse. I want to ask, what would the costs involve? Does it include legal costs? I want to talk about paragraph 9.5 of Schedule 7. If there are different legal costs and the costs associated, say, with utilities, operations of the panel, is it C3095? Well, any of the costs and expenses incurred, really, the appeal board may make an order. Thank you.
新強
Mr. Ambrose Lam. Chair, Clause 48, bracket 4 in the Chinese text. I think there are two typos. Which clause are you referring to? Clause 48, bracket 4. An organization that lodges an appeal under subsection 1 against a decision may, at any time. It seems that there are two typos in the Chinese text. 委出 should be replaced with 被委任 in Chinese. May I defer to the law draftsman? Thank you. Now, the appeal board appointed for the appeal. First of all, the appeal panel would be appointed, comprising various members. So the appointment refers to the membership of the appeal panel. I understand what you're talking about, but I don't think it is easily understandable from the Chinese text. So that is an appeal panel appointed for the appeal. We will try to improve the Chinese text. Since there are no other questions concerning Part 7 appeals, we will move on to Part 8. Clause 50. I will explain clauses 50 to 52 altogether. Clauses 50 and 51, appointments of authorized officers by Commissioner and by designated authority. The functions and roles of the authorized officers are set out in Part 5 and 6. Commissioner and designated authority can appoint authorized officers and authorized employees. There is a catch-all provision so that any other persons, as approved by the Secretary for Security, can also perform the function. Now, Clause 52, delegation of functions. Functions to be performed by the Commissioner and designated authorities can be delegated to authorized officers or any other employees. Any question about these three clauses? Now, these clauses are very common for law enforcement agencies. Clause 51, brackets 1c, with the consent of the Secretary for Security, any other person or class of persons can be appointed. So for cases where the designated authority do not have internal expertise to deal with a case, then outside experts may have to be engaged. So with the consent of the Secretary for Security, these persons can be appointed as authorized officers. But that is not necessary for the Commissioner. That is true. Allow me to elaborate. Brackets 1c is a catch-all provision. As a designated authority, the authority must have their own in-house experts in the trade. Otherwise, they will not be designated as an authority. However, in certain incidents, an expert with specific expertise may be required. So, subclause 1c is a catch-all provision. Now, within the Commissioner's office, we will have the relevant experts in various fields. So that is not necessary for the Commissioner. Mr. Lai Tong Kwok. Clause 51, designated authority. It may, in writing, appoint a public officer. Now, the two designated authorities in the bill do not have public officers working within them. So why do you give them the power to appoint a public officer? 50, Clause 50, is fine because the Commissioner's office is a government department. But how can a non-government body be given the power to appoint a public officer? I think B is clear enough. A person employed by the authority or in connection with the authority's performance. And also there is subclause C as well. With the consent of the Secretary for Security, you can appoint a class of persons to act as the authorized officer or the designated authority. Why do you need to give them the power to appoint a public officer? Security Bureau. Now, the Communication Authority is one of the designated authorities. Please speak into the mic. In the OFCA, there are some civil servants. I mean, most of the members of the office of the OFCA are civil servants, so they are public officers. And it is foreseeable that there will be other designated authorities designated in the future. The HKMA does not have an establishment of civil servants, but maybe in the future there will be other designated authorities which have public officers in them. Clause 53. Specified officers. So please move on to Clause 53. Specified officer in Clause 53. So these are the authorized officers mentioned in clauses 50 to 52. Specified officers are also authorized officers delegated with functions. Now, the specified officer may be assisted by any person whom they reasonably requires to perform their functions. There are similar provisions in other ordinances as well. No questions, please continue. Clause 54. During policy discussion, we have also mentioned a catch-all provision. Under specific scenarios, as mentioned in bracket 2, that is for the timely protection of the critical computer systems and also in the public interest, the Commissioner must not perform the function unless the Commissioner is satisfied that certain conditions are met. Clause 54, subclause 2A and B. When will the Commissioner invoke these subclauses? Well, like my colleague said, these are very exceptional circumstances. If the Commissioner invoke the power in subclause 2, there is a threshold. That is, it is necessary to do so, and also it is in the public interest to do so. Say, for example, the HKMA's computer system has been hacked and is not functionable. So we can't sit idling. The Commissioner's office has to intervene to restore the security of the computer system. Clause 55. Commissioner may exempt CI operators from certain responsibilities. Normally speaking, the CI operators has to fulfill categories 1 to 3 responsibilities. However, considering public interest and that the responsibilities have been fulfilled by similar measures, then the operators can be exempted from certain responsibilities. Mr. Lai Tongguo, sorry, I would like to go back to Clause 54. Now, in the title, the word necessary is used. In Chinese, it is 必要. In bracket 2, you also use the term necessary, 必要 in Chinese. In my opinion, there can be two translations for necessary, 需要 or 必要. But they are different in terms of the extent in Chinese. 必要 is a must. 需要 has a lower level of urgency. but both are viable translations. So in saying necessary, what are you trying to express? Security Bureau. I thank Mr. Lai for his question. We are saying this is really necessary and it must be done. So in Chinese, it is BU. So based on the suggestion of Mr. Lai Dongkwok, we will revisit whether the translation is appropriate. Clause 55. I have covered Clause 55. Any questions about exemptions? In operation, there are scenarios where the sectors should be given an exemption since they have already fulfilled the requirements. Yes, we are trying to build a partnership with the operators. We want to be the facilitators for the business. Say, for example, a drill. The operator has already conducted a drill of a similar scale to our standard. Now, if the objective of identifying areas for improvement has been fulfilled, then we can give the operator an exemption. The intent is to provide convenience to the operators and to save cost. Subclause 4, there can be conditions pertaining to the exemption. For example, requiring the operator to take certain actions. Yes, if there is some parts missing in the drill, then we can require the operator to conduct drill solely on that part. Mr. Lai Tong-kwok, Clause 55, bracket 3, page Z3026 in the English version of 3027. The Commissioner may take into account the factors mentioned in the following. So in terms of public interest, the Commissioner has to take into account two factors. I think this is very important. I mean, the factors are very important. That's why you are including it in the bill. You said the Commissioner may take into account the factors in A and B. So in my understanding, these factors are very important. So I suggest replacing the word may with shall. As the Permanent Secretary said, he wants to reassure the sector. So if you are saying that the Commissioner shall take into account the following factors, it would give the greatest reassurance to the sector. The word may, however, connotes that it is not a must. So maybe you should change the word into shall. Thank you, Mr. Lai. We will consider your suggestion. As I've said, the intention is to facilitate the operation of the business. So we will try to improve the wordings. Please continue. Clause 56. Designated authorities may prosecute offences. The scope includes the offence in Section 7, failure to comply with the direction given by the authority, an offence under Section 18, failure to comply with the requirements imposed by the authority, offence under Division 1 or 2 of Part 4, failure to comply with a Category 1 obligation, and Section 45's offence, failure to comply with the requirements imposed by an authorised officer. Now, there is not a similar power given to the Commissioner because the Commissioner has been delegated a power by the Secretary for Justice to prosecute the offences. However, designated authorities need the power to prosecute offences. Please continue. 57. Preservation of secrecy. Under normal circumstances, Any person have access to any matter relating to the affairs cannot divulge the information to other persons. Now, under subclause 2, there are some exemptions, including information already disclosed to the public and also information for the purposes of any criminal proceedings. Subclause 3, a regulating authority may disclose information to certain people, for example, the chief executive, the chief secretary for administration, the financial secretary, and the secretary for security, and so on. Under normal circumstances, they cannot disclose the information to any other persons, otherwise it would be an offense. Now, in terms of the offense, disclosure in breach of Clause 57 carries a maximum penalty of $1 million and a term of imprisonment. So can you explain subclause 4? The regulating authority must not disclose information unless the authority is of the opinion that, and so on, so on. So there are some conditions to be met for disclosure, even in relation to criminal proceedings. Now, the confidentiality clause achieved several purposes. That includes protection of trade secrets and personal secrets. It is clearly said that the disclosure can only be made in accordance with the law and during the investigation. Now, the bill targets computer security incidents. Investigation is not for the purpose of gaining personal secrets or trade secrets. Now, subclause 3, information may have been disclosed to government officials. So this must be related to the functions to be performed by the government officials, for example, the Secretary for Security. This is another layer of protection to ensure that the information gained during the investigation would only be used in accordance with the law and not disclosed to anyone else. I will give you some time to read through Clause 57. Any question? Mr. Lai Tong Kwok. Thank you. I need to clarify one thing with the administration. According to 57 subbrackets 3, a regulating authority may disclose information to a number of public offices specified in the bill. Can the administration confirm this? Say, for example, disclosure to the financial secretary. Is the information disclosed to the financial secretary himself or his office? In other words, anyone can get the information on a need-to-know basis. Let's say if there is an incident that you need to report to the financial secretary. So we don't expect the financial secretary to handle this all on his own. He needs his team to support him. In that case, it is inevitable for him to disclose the information or part of the information to his team. So please confirm that by financial secretary, you mean those working in his office or the financial secretary himself. So the point of disclosing the information to the government officials are for them to take actions.
延長15分。
Before I allow the Permanent Secretary to give an answer, I need to extend the meeting by 15 minutes. Mr. Lai's understanding is correct. Those who are given knowledge must be those related to the duties of the post holder. Now, perhaps Ivan can give you a more detailed answer on what relative personnel means. About the disclosure under 3A, the premise is that the conditions in subsection 4 must be met. Disclosing information to the FS, the Secretary for Justice, or Secretary for Security. Disclosure can only be made after meeting the conditions, that is, for the department secretaries or bureau chiefs to fulfill their official duties, and that is not against public interest. Only when the two conditions are met can information be disclosed to the post holders. Now, the next question is whether information is to be disclosed to the financial secretary only or to the financial secretary's office. That depends on the circumstances. For example, by including the disclosure of information to the financial secretary, we don't mean that automatically the financial secretary's office will be included as well. It depends on whether there is a need for the staff in the office to support the FS in fulfilling the duty. In fact, if we turn to 3A and then Roman numeral 10, a public officer authorized under subsection 9. So that's also related to the safeguards to make sure that information will be disclosed on a need basis. Right, what if the secretary authorizes a public officer so and so? Does it refer to a class of persons or a particular person? Say, the authorization should only be granted after the proper documentation is ready. Now, the way this is drafted, by suggesting that a public officer can be authorized, is it wide enough in scope for the Secretary for Security, for example, to authorize a public officer by name or by office, and I have to phrase this in English, to do certain acts? Because it's supposed to be very rigorous. I just want to know whether the wording here could meet the legislative intent. In fact, in subclause 10, I think there are relevant definitions. Related person, specified person. Mr. Lai's understanding is correct. Be it authorization given to a person, a post holder, or a class of person, all these are permitted under the subclause. This is in fact the standard approach when it comes to preservation of secrecy. Right, let me ask members. I've extended the meeting to go beyond 1 p.m. Now we have just about 10 clauses left. Do we agree to go on? It's been 4 hours. All right, this is supported by members. So please continue. Clause 58, offenses relating to Section 57, and that's a maximum fine of $1 million and imprisonment for 2 years. Clause 59. P.S. I have a question here. Is it possible for me to be the watchdog in this case? Will I be confined to Section 57? That is, if I want to know the details about disclosure of information, Of course, as legislators, your job is to monitor our work, including the work of the Commission's office. So I want to know whether this clause will put a straight jacket on us. Under normal circumstances, the Legislative Council, especially the panel in question, will be monitoring the work of the government. Now, as long as specific personal data are not involved, I don't think this secrecy provision will get in the way of the work of the Legislative Council. In fact, if we turn to bracket 3, bracket C, that's C3035, the specified person may disclose information in summary form to prevent the identity of the person being revealed. So that's basically how it works. Alright, I note your explanation. Because for specified person, that's a subject of disclosure, you have not included a member of the Legislative Council, and you just also refer to 57.3c. Please go back and consider including council members in the specified person as well. All right, 59, protection of informers. Again, these are standard clauses. It provides that for the identity of the informer or the person assisting in the investigation process must not be disclosed as evidence in the legal proceedings. We have similar provisions in the AFRC ordinance. Clause 60, immunity. For the purpose of complying with directional requirement in the ordinance, this person does not incur any civil liability. These are, again, standard provisions. 61, legal professional privilege, a technical safeguard. 62, again, a technical provision, production of information in information systems. Information should be provided in a legible form, albeit electronically. Clause 63, lien claimed on documents. A person claims a lien on any document does not affect the requirement to produce the document. Clause 64, disposal of property. In the investigation process, any property so retrieved could be disposed of according to the Criminal Procedure Ordinance. Now, clauses 65 and 66 have been discussed when we discussed the merits of the policy. Please walk us through very briefly. 65, due diligence. This is a defense that is the non-compliance with the provisions relate to something that is out of the control of the defendant. Reasonable excuse, clause 66. That is, notice should be given in relation to this defense within 7 days. And then there is also the evidential burden being discharged to raise a live issue at the legal proceedings. So there are two different thresholds here. Let's explain the two thresholds, and then we'll go to the next one. Reasonable excuse relates to 1842, failing to provide information as required, failing to comply with the requirements in the investigation process, etc. The reasonable excuse could be a valid defense. Of course, the onus is evidential burden. Let me also supplement from the policy's point of view. For the point of law, I'll give the floor to the DOJ colleague. Now, I want to explain this point because it's all about reasonableness and proportionality. The objective of this bill is to ensure that CI operators can fulfill the Cat 1 to Cat 3 obligations. So they must fulfill the due diligence test, and that's a higher legal threshold. By means of due diligence, the CI operator is required to provide information to meet the certain requirements. You can't tell us that the computer system is out of order and that's it. You need to come up with, say, a plan B. Perhaps you have a backup copy of the data. You need to exhaust all means to make sure that you've done your best to comply with the law. Now, for reasonable excuse, it relates to the investigation process and the submission of information and documents, etc. So that's a lower threshold. We believe that a lower threshold, such as a reasonable excuse, should be allowed, such as the malfunctioning of the computer system. And that's the policy rationale in terms of appropriateness and proportionality. 67, service of notice. It sets out how the notice should be served on a regulating authority. That is in the form of delivery by hand or by post. We've made reference to the CAP 604A Guest House and Accommodation Ordinance and other. This is a common provision in different ordinances. Clause 68, certificates. For proof that this CI operator is a designated CI operator. It's a technical clause. Clauses 69, 70 should be read together. 69 provides that the Secretary for Security may make regulations for the better carrying out of the provisions of this ordinance. It will be done by way of subsidiary legislation, by negative vetting, in other words. Clause 70. The schedules may be amended by way of subsidiary legislation. Mr. Lai Tong Kwok, I have a suggestion for the administration. We've spent time reading your bill, and you've, of course, spent so much time drawing up this bill. We share one objective, and that is to protect critical infrastructures. Now, you're going to create the post of a commissioner who will be in charge of everything, who will be given various powers. So, of course, the commissioner will enjoy more powers than the regulating authorities. Now, clauses 69 and 70 allow the Secretary for Security to make regulations and to amend schedules by subsidiary legislation. This is, of course, necessary for the Secretary to fulfill his responsibilities. Now, I'm thinking, under some circumstances, the Secretary could make directions for the commissioner to perform certain acts. It's only reasonable for the Secretary for Security, who is the primary person in charge of security in Hong Kong, to take up this responsibility and have the authority. Now, how about including this clause here? The Secretary for Security may also issue directions to the Commissioner for the better carrying out of this ordinance. Now, this is the trump card for the security chief to issue some directions to the Commissioner for the better carrying out of the ordinance. Please go back and give it a thought. We'll go back. I'm sorry, we are 20 seconds from the time for adjournment. I need to extend the meeting by 15 minutes again. Please continue. You have spelled out the object of the bill, and that is the commissioner and the commissioner's office enjoy the power of supervision, and we'll go back and consider how this is best entrenched in the bill, including the written direction, the directions point. I also fully agree with the member's suggestion. Now, the commissioner is to be appointed by the chief executive according to clause 3, and then in the future, you may be applying for funding for the establishment of this post along with the commissioner's office. There'll be a roadmap, and you give us an org chart. But after all, these are not contained in the bill. For the sake of clarity, you need to give us a better picture about the powers enjoyed by the Secretary for Security and the Commissioner in ensuring the security of critical infrastructures. Now, for the schedules, I think we have very briefly read through the schedules. I'll give you 1 minute to check the schedules again. Mr. Ronick Chan. I'd like to turn to part 3. Which one, please? Schedule 7, part 3. Appointing panel, an appeal panel. Now it says, in terms of composition, there should be at least certain numbers of members of the appeal panel, and then what it follows is at least two of the members are IT professionals, at least 2 of the members are legal professionals, and then at least 2 of the members are neither IT professionals nor legal professionals. That's ordinary members, but there is no definition of what an ordinary member means. And then I think this is quite tricky if you don't have a definition. Now, A, the chairperson, and then B, 2 other members who are not chairman, and then C, at least 1 member who are not chairman of the panel. And then by doing so, you don't need to coin another term referring to ordinary members. So, because the composition differs every time, is for the chairman to pick 3 or more members of the appeal panel. So, in other words, 1 chairman plus 2 members. This is clear enough. I don't think you need to coin another term called ordinary members. I will go back and mull over Mr. Chan's suggestion. What is important is to enhance clarity. I will review the drafting of this provision. Thank you. Mr. Robert Lee. I see financial services in Schedules 1 and 2. Very often we refer to financial services as well as banks. I think that we've clarified the point on a number of occasions. We are not referring to the exchange or CCAS, a central clearing and settlement system. But to avoid misunderstanding, you need to consider the special meaning of financial services in the context of elections. For example, they also include practitioners in the precious metal sector as well as the Hong Kong Exchange. Now, you've stuck to banking and financial services. Have you considered in other ordinances, the phrase banking and financial services may carry a different meaning? We understand why you have provided this term, but I just want to make sure that you've given it a thought. Any views?
我理解
Permanent Secretary, let me give you some background information. When we discuss policy-related measures, members have expressed some concerns about Schedule 2's industries, and this information can also be seen in the list of list of follow-up actions arising from the meeting, such as the central clearing and settlement system. I understand that for column 4 of part 2 of Schedule 2, you do not include such in the list of regulated organizations. But does it conform to what is said in clauses 11 to 13 on the designation of the critical computer system CI operators or ascertaining the critical infrastructures? We also discussed whether EMPF is included as a regulated organization. There are some views that the central clearing and settlement system deals with 40 trillion shares transactions, and we are using banking and financial services, this expression in Schedule 1. So we want to know whether you only want to regulate the banking systems or what with this expression. Thank you. Permanent Secretary, we would say this is dynamic. When we talk about the sector, we want to, of course, have some flexibility. But say today we will have the Hong Kong Monetary Authority being the regulating authority. We would want to have the regulated organizations by HKMA, but even if it is not regulated by the HKMA, it may still be regulated. We're just talking about who the regulating authority is. If we think a particular organization is operating essential services, or their data may affect societal and economic activities, they may still be designated as critical infrastructure. With this here, the schedule here, we're talking in particular who the regulating or designated authorities are. The criteria have always been whether it is providing essential services and whether it will substantially affect the societal and economic activities of Hong Kong when ascertaining critical infrastructure. I think the key is, as said before, at a certain point in time. For certain systems, say the central clearing and settlement system is deemed to be critical infrastructure, we need to be prepared for such regulation. We do not really have a clear definition just yet, but once it is clear, you must give enough time for the industry to be prepared. Please rest assured, we are all about trying to form a partnership, and we'll make sure adequate time is given to operators to prepare. All right, thank you. Everyone, with concerted efforts, we have completed scrutiny of the Chinese text. I will now ask the legal advisor to confirm that the English text is also does not have any legal or drafting issues. Thank you, Chair. We do not note any inconsistencies between the Chinese and English text, nor is there any drafting or legal issue with the English text. All right, for the views raised by members or some points that you may wish to clarify, you should provide a written reply. As per usual, the Bills Committee will consider any amendments proposed by the administration, the Bills Committee, or individual members for the bill. If members would like to propose amendments, the deadline is 11th of February, Tuesday. Before that or on that day, the draft amendments should be submitted to the Secretariat. If any, the administration will also provide a written response in relation to the draft amendments so that the Bills Committee may consider such amendments. Security Bureau. I would like to take the chance to thank the chairman and members of the Bills Committee for providing us with valuable input on enhancing the bill's provisions. I would like to take this chance again to thank members for providing us with valuable feedback. I would also like to thank the chairman again. Thank you. Permanent Secretary, we were going to have another meeting on 14th of February between 9 in the morning and 1 p.m. I guess it depends on when you can submit a reply and whether members would like to propose amendments. We'll see whether we will go forward with the meeting. If there's no other business, meeting adjourned.